Good day, everyone. Welcome. Today, we will discuss the evolution of fundamental rights in India. When we think of the term fundamental rights, what comes to the mind? Maybe the right to equality in Article 14, freedom of speech in Article 19, or right to life in Article 21 of the Indian Constitution. But have these rights always been the same? The answer is no. Over time, judicial interpretations, amendments, and political events have reshaped and redefined these rights. For example, did you know that the right to privacy was not originally considered a fundamental right? It was only recognized in 2017 in the Potoswamy case. Similarly, the right to education was not fundamental until the 86th Amendment in 2002. So, we will explore how fundamental rights were originally framed, how they changed due to landmark Supreme Court cases, and how modern challenges are reshaping these rights today. Let's begin by understanding the historical background of fundamental rights. To understand the evolution of fundamental rights in India, we must first look at their origins, British rule and colonial laws. Before independence, Indians had no guaranteed rights. The Rowlatt Act 1919 allowed imprisonment without trial, and sedition laws crushed free speech. This led to demand for a Bill of Rights. Influences from other countries while framing the Constitution. The framers of the Constitution studied various models. US Bill of Rights inspired a right to freedom and due process. Irish Constitution influenced our directive principles of state policy. Universal Declaration of Human Rights in 1948 helped shape our approach to social and economic rights. The Constituent Assembly was in debates for 3 years, from 1946 to 49. Leaders like Dr. B.R. Ambedkar, Sardar Patel, and Nehru debated extensively. The key outcome was Part 3 of the Indian Constitution, which enshrined fundamental rights as justiciable, meaning citizens could approach courts if their rights were violated. So, what made to the final list of the fundamental rights in 1950, when India became a republic and constitution came into practice? When the constitution came into effect, we had 6 categories: right to equality, described in Article 14 to 18, right to freedom, described in Article 19 to 22, right against exploitation in Articles 23 and 24, and right to freedom of religion in Article 25 to 28. Cultural and educational rights in Articles 29 to 30. Right to constitutional remedies is described in Article 32. Dr. Ambedkar called Article 32 the heart and soul of the Indian Constitution because it allows citizens to directly approach the Supreme Court when their rights are violated. But how did courts interpret these rights in the early years? Let's find out. In the early years, the judiciary took a restrictive approach to fundamental rights. In A.K. Gopalan versus State of Madras in 1950, the Supreme Court ruled that personal liberty could be curtailed as long as the law followed proper procedure and limiting its scope. In Golaknath versus State of Punjab in 1967, the court ruled that Parliament cannot amend fundamental rights, setting the stage for conflict. In the landmark judgment of Keshavananda Bharati versus State of Kerala in 1973, introduced the basic structure doctrine, stating that Parliament cannot alter the core values of the Constitution, including fundamental rights in the Part 3 of the Indian Constitution. However, these rights were severely curtailed during the emergency. In 1975 to 1977, the infamous ADM Jabalpur case of 1976, also called the habeas corpus case, ruled that citizens had no right to liberty or life during an emergency. This was a major setback, but the judiciary later reversed this in subsequent years. After the emergency, the judiciary adopted a progressive approach, expanding fundamental rights through Maneka Gandhi versus Union of India in 1978, redefined Article 21, ruling that right to life includes due process and human dignity. Another case is in Sawhney versus Union of India in 1992, which defined affirmative action in reservations, ensuring a balance between equality and social justice. In Vishakha versus State of Rajasthan in 1997, recognized sexual harassment at workplaces as a violation of gender rights. This era saw the rise of public interest litigations, allowing citizens to seek justice for marginalized communities. As we move into the 21st century, the interpretation of fundamental rights has undergone a massive transformation. The Constitution was drafted in 1950, but modern challenges like digital privacy, AI regulation, climate change, and new social rights were never envisioned by our founding fathers or the leaders of Constituent Assembly. So, how has the judiciary responded? Let's look at some key Supreme Court rulings and modern challenges shaping the future of fundamental rights in India. The right to privacy is a new fundamental right, described in Justice K.S. Puttaswamy versus Union of India in 2017. For decades, there was no explicit right to privacy in Constitution. However, as technology advanced, issues like Aadhaar, data surveillance, and digital rights became critical. In the landmark Justice K.S. Puttaswamy case of 2017, a 9-judge bench of the Supreme Court unanimously declared that the right to privacy is a fundamental right under Article 21, which states right to life and personal liberty. The judgment had major implications. It led to safeguards against government surveillance. It strengthened data protection laws, influencing the Digital Data Protection Act, Digital Personal Data Protection Act of 2023. It reinforced personal autonomy, influencing later judgments like decriminalization of homosexuality and women's reproductive rights. However, the challenge today is data privacy. With the rise of AI, big tech, and surveillance capitalism, how do we balance national security with personal freedom? That's a question we will have to keep debating. LGBT rights and decriminalization of Section 377 in Navjot Singh Johar versus Union of India in 2018. For over 150 years, homosexuality was criminalized under Section 377 of the IPC. The British era law violated the right to equality in Article 14 and the right to dignity under Article 21 of the Indian Constitution. In 2018, the Supreme Court in the case of Navtej Singh Johar versus Union of India struck down Section 377, legalizing consensual same-sex relationships. Key observations of the court in that case is the LGBT community is entitled to full dignity and equality. Sexual orientation is an intrinsic part of identity, not a criminal act. The judgment laid the foundation for discussions on same-sex marriage and adoption rights. While the judgment was a historic win for the LGBTQ plus rights, challenges remain. Same-sex marriage is still not legally recognized in India. The battle for full equality continues. Women's rights, the battle against triple talaq. In Shaira Banu versus Union of India, in 2017, the Supreme Court in the case declared the practice of triple talaq, which is an instant divorce in Muslim law, unconstitutional. Why was triple talaq abolished? As it violated women's right to equality described in Article 14. It was arbitrary and left Muslim women without legal protection. The courts ruled that the practice was not an essential part of Islam, allowing Parliament to pass the Muslim Women Protection of Rights on Marriage Act 2019, which made triple talaq a punishable offence. What are the modern challenges to women's personal rights? There is still no uniform civil law for personal matters like marriage, divorce, and inheritance. The debate on uniform civil code is gaining momentum. Should India move toward a common legal framework for all religions? That remains a contentious issue. The right to free speech versus hate speech is a growing dilemma. The right to free speech under Article 19, Clause 1, Subclause A is essentially in democracy. However, it is not absolute. The government can impose reasonable restrictions in cases of national security, public order, incitement to violence, or hate speech. The rising free speech controversies are the use of sedition laws under Section 124A to silence journalists, activists, and political opponents. Cases like Vinod Dua versus Union of India in 2021, where the Supreme Court quashed sedition charges against a journalist. The debate around social media censorship. Should platforms like Twitter, Facebook, and YouTube regulate hate speeches? Or does this lead to overreach and suppression of dissent? The big question. Are current hate speech laws enough? Or do they need clearer definition to prevent misuse and political weaponization? What is the next frontier? It is digital rights and AI ethics. In the coming years, the biggest challenge to fundamental rights will come from AI in the form of AI surveillance, facial recognition, data protection, and deep fakes. Major concern for everyone is facial recognition and biometric tracking, a risk to privacy. Deepfake technology, a tool for misinformation and political propaganda. AI bias in legal decisions. Can court use AI to decide cases? What is the future role of Supreme Court? It is setting boundaries on government surveillance, balancing national security versus digital privacy, regulating AI-driven legal decisions, or should machines replace judges? Fundamental rights must evolve to protect digital freedoms, just like they evolved to protect gender and social freedoms in past. To summarize, fundamental rights in India have constantly evolved from early interpretations in 1950s to expansion in the 1980s to 2000s, to new digital and identity rights in the 21st century. What are the key takeaways from today's video? Privacy was not originally a fundamental right, but now it is. LGBTQ rights have only recently gained constitutional protection. Human rights and personal laws are still developing or evolving. The future will focus on digital rights, AI ethics, and free speech versus hate speech. Final thought for today's video is fundamental rights are evolving. Do you think the Supreme Court should expand rights further? Comment below. I'll see you in the next video. Thank you.